SJC-10325, Commonwealth versus Narea.
Okay.
Good morning, Ms. Lynn.
Good morning. May it please the Court. My name is Alexandria Lynn. I'm here today on behalf of Manuel Narea, the defendant, on appeal from the single justice's vacation of the district court's order excluding testimony at trial of buy money. The single justice's order must be vacated in this case because affirmance of that order would open the door for a precedent giving litigants grounds for countless unnecessary petitions for interlocutory relief under 211.3, where this case, which, as this Court knows, is entirely contrary to the objective of reserving review only for extraordinary circumstances. To date, this Court has never approved under 211, Section 3, consideration on the merits of a case where the Commonwealth appeals from an interlocutory order, but where the Commonwealth has failed to demonstrate either of two things. Either that the order by the judge has violated a substantial interest of the Commonwealth, or where review is appropriate to superintend the administration of all courts of inferior jurisdiction. Here, the Commonwealth has made no showing whatsoever that a substantial right has been violated. Rather, the Commonwealth seems to point this Court towards the idea that it's necessary for this Court to review the issue in order for the proper administration of justice. But a review of cases where the Court has done so under that second category of review under 211.3 reveals that those cases are reserved for those where it has far-reaching implications for the administration of justice over various lower courts within the Commonwealth rather than on a case-by-case basis.
I take it, Ms. Lynn, that you made this argument to the single justice.
Yes.
The same argument.
In less detail.
That is to say that relief under 211.3 was not appropriate.
The argument was made to the single justice that relief under 211.3 was not appropriate because the Commonwealth had not demonstrated a violation of one of its rights.
Right. So the single justice then decides to reach the merits of the case rather than say that relief is not warranted, and I'm not going to indicate one way or the other on the merits. And we are here reviewing the single justice's decision under what standard?
Abuse of discretion.
Okay, so that's a pretty difficult standard for you to meet.
Yes, I understand that. However, if this Court affirms his order, then every time a litigant has the feeling that they've received an adverse ruling that is contrary to law, they're going to come up here under 211.3 because
they might, and then the single justice decides that it's not an
yes,
appropriate.
but that has the effect of stalling cases, and in the case where it's necessary to appeal maybe under Rule 221 of the SJC rules, then it stalls the case and the defendant is waiting on trial. In this case, it's taken 6 months. This has delayed the case. It's not necessary. Well, back to the administration of justice, it's not necessary for this Court to review such cases.
What happens if it is? I mean, this is not a defendant's case. I mean, the ruling is not adverse to the defendant. But what happens, leaving aside this case? Well, I mean, it's specific to this case. But as you know, if there's an acquittal, the Commonwealth doesn't have a right to appeal. Correct?
That's correct.
And what happens if the Commonwealth attempts to persuade a trial judge on an evidentiary ruling? The trial judge makes an evidentiary ruling deciding to exclude certain evidence, and the basis of that ruling appears to be in conflict with a case directly on point by the Supreme Judicial Court.
Well, in that case, the Commonwealth would still maintain the burden of showing the single justice that the judge's ruling had violated a substantial right. For instance, as this Court explained in Anderson in 87, which was a hearsay issue, that it somehow affected the Commonwealth's ability to prosecute the case, that it was a substantial piece of evidence. And that's the reason why the Commonwealth has the right to seek appeal under Criminal Procedure Rule 15.
No, I understand
because it's sort of
that.
the corpus delicti of the case. Here, it's just
Do you think the decision of the judge in the Boston Municipal Court on this on the evidentiary point was consistent with Commonwealth against Key?
I'm sorry?
Is it your understanding that the decision of the on the basis of the buy money, do you think that is consistent with the Supreme Judicial Court's decision?
No, that is not my position, Chief Justice. At first glance, this case seems to be on point with Key. Initially, I note that Key was decided on an abuse of discretion standard. Now, that being the case, it would not be inconsistent for the lower court here to determine that the appropriate remedy was to exclude testimony and still be in keeping with the holding in Key.
Refresh my memory about what we said in Key.
In Commonwealth v. Key, this court said that the defendant hadn't met his burden for showing a reasonable possibility that the evidence was potentially exculpatory, where the Commonwealth did not produce copies of the bills or the bills themselves at trial.
Okay, so what? And therefore, there was no remedy. And
therefore, the lower court did not abuse its discretion in declining to either dismiss the case or exclude the testimony regarding the buy money.
And that seems right on point with this.
As I said, at first glance, it does. And even if that were the case, I maintain that the
single justice said the remedy was to exclude. The defendant moved to dismiss the case, correct?
Yes.
And the judge in the Boston Municipal Court said, no, you're not going to dismiss the case, but what I'm going to do is preclude the Commonwealth from eliciting testimony from the undercover police.
Correct. And in so doing,
about
he cited
about what happened about the marked money, correct?
Correct. There are differences between this case and Commonwealth versus Key. Firstly, in Commonwealth versus Key, this court focused a lot of its attention on the fact that this was not, in fact, a spoliation case. What it was an issue of the officer's credibility. Because in Key, what had happened was that the investigating officers marked a number of $10 bills.
I remember the facts of the case, yeah.
Right. And so this court determined that even if during discovery or at trial the Commonwealth had produced the bills, that there was no way to know that those were in fact the bills that were found on the defendant. So it really came down to an issue of the credibility of the officer.
Because in that case, they were circulating the marked money, right?
Correct.
They would buy it. They'd arrest the purchaser. I mean, they'd arrest the seller of the drugs. They'd get the money back, and that they'd put the money back out into the.
Correct, but additionally, in that case, a number of bills were all marked with the same symbol. The same sixes in the trees.
Here you've got individual markings.
I'm sorry?
Here you have individual markings.
Here, the serial numbers of the bills were allegedly written down on a piece of paper before the undercover officer went out into this drug transaction. So this is really not an issue of the credibility of the officer, where if the numbers were pre-recorded, the best evidence of what money they found on the defendant, what bills they found on the defendant, is really the bills themselves. And that's not a credibility issue.
But, so you're saying, as I thought they were saying in Key, that you want the bills in, right? Isn't that what you're saying?
You want the bills in, and the Commonwealth doesn't have the bills because the bills are out there.
Correct.
In the undercover world.
So what's the difference?
Nobody made a copy of the bills.
Here, nobody made a copy.
So defendant is arrested. They pre-mark the bills. The police seize the bills. They
And
don't make a copy.
recirculate them.
And they just recirculate.
Yes,
So
in
you can't
Commonwealth-
match up the seized bills with the pre-recorded.
Correct. In Commonwealth versus Key, the Commonwealth had offered that they didn't have a photocopy machine. Here, there's nothing on the record regarding that. So if the defendant had come back and the officers had taken the money off the defendant and it matched up, that's the best evidence of whether or not those bills matched up the numbers that were originally written down. Excuse me. So that's not really a credibility issue at all. I'd also like to call the court's attention to, in Key, there was, I'm running out of time here,
an
issue of concrete evidence.
I get your point. Your point is that it's not so clear that Key controls here.
Correct. In addition here, on the serial numbers that were written down purportedly before the investigation, the buy took place, there was a star next to one of the bills, next to one of the serial numbers, and that's what the lower court called particular attention to in this case. That's one of the things he wanted a photocopy of that bill in particular because he thought there was something going on here. There was something sort of fishy here. So I see that my time is up. If there
You
no
are
more
a
questions.
remarkably wise counsel to see that your time is up as opposed to trying to run the gauntlet before I cut you off. So thank you very much for that.
Thank you.
Ms. Saxe?
Good
Good
morning,
morning.
or by now, good afternoon, Your Honors. May it please the Court, Hella Saxe on behalf of the Commonwealth.
Could I ask you a question?
Of course.
What, with respect to the judge's order, no evidence of the buy money? What was the judge's order?
The judge's order was that no evidence of the buy money could be
So
introduced
does that
at
mean
trial.
that no one could testify that they gave the was it $1,600?
Yeah, something like that.
It's $160. That nobody could testify that he gave $160?
I believe in the extreme it could mean that no mention of money could be made in this trial at all. There could be no testimony
Well,
that...
the judge didn't say that. The Commonwealth could have tested that. Said the Commonwealth could have said to the judge, "Judge, are you telling me that I can't elicit testimony from the police officer that he paid?"
$160.
Well, that would include testimony about buy money, I would submit. And
But
that
you
would
didn't.
be-
The Commonwealth didn't test that. They didn't go to the judge and say, "Judge, I don't understand your order. You're saying that I can't elicit testimony that we marked the dollars and that when we arrested the defendant, the marked dollars were on the defendant, or are you saying I can't elicit testimony that the police officer paid $160?"
The Commonwealth did not question the judge any further. However, the defendant had requested a sanction. In his motion to dismiss, had proposed an alternative, either to dismiss the complaint or to issue a sanction to prevent Sergeant Fitzpatrick from speaking about buy money. And Sergeant Fitzpatrick is the officer here who marked the bills and who then gave them to Officer Stoddard, who conducted the undercover buy. And Sergeant Fitzpatrick then later compared the recovered money with the bills, the numbers that had been written down. And the judge, in his order, goes far beyond that. The order doesn't limit it to testimony from Sergeant Fitzpatrick, but in fact includes all testimony about buy money, and that would also include Officer Stoddard testifying that he used the money or he received it and then used it to conduct the undercover buy.
Ms. Saxe, could we just turn to the main thing here, which is 211.3 is a very limited opportunity for appeal. You have an evidentiary ruling, and you have and the judge then enters relief for the defendant of some kind in the normal course of trial. Why, if we decide that the merits should have, it was appropriate for the single justice, or let me put it this way, it wasn't an abuse of the discretion of the single justice to consider the merits, would I not anticipate that we're just going to get endless 211.3 petitions from the thousands of cases that the Commonwealth is prosecuting every day?
Right. I would submit that would not happen in this case, or as a result of this case. First of all, the 211.3 is appropriate because the Commonwealth did not have an appellate remedy. This does not fall under Rule 15 because it wasn't an allowance of a motion to dismiss or an allowance of a suppression.
But you're almost never going to have an appellate remedy except if the evidence is a motion to suppress is granted. You're never going to have an appellate remedy to an
Right.
evidentiary ruling.
And that addresses
But isn't the answer that this is akin to when the Commonwealth loses on a motion to suppress because you're losing your key piece of evidence? You
Exactly.
lost it as if
Well,
you lost
and
a
here
confession
it was-
or a
You're not.
piece of
You're not.
evidence.
This is not a key piece of evidence.
Yeah.
The drugs are the evidence.
Well, the money is too. If it were excluded, the complete...
It's just a piece of evidence. I don't know how it's a key piece of evidence. So what's excluded? The fact
Well-
that you actually then took the money off the individual and matched it to the numbers. If that's excluded, you've lost an important piece of evidence by your own conduct. But
That's not, you interpreted it much I mean, if that's all it is, would you say that that was something that...
No, it isn't. If I think there are two questions out there right now. First of all, Chief Justice Marshall's question, this would not come back on a routine basis because here the lower court judge, in fact, committed an error of law. And key is, as is our position, exactly on point, that this
Let's say we
evidence is
disagree
not
with you. Let's say we disagree with you. So you may or may not be right. I've listened to Ms. Lynn's argument. Let's say it's not directly on point. There was an abuse of discretion. We said it was or wasn't an abuse of discretion. So it's not directly on point.
Well, here, the lower court judge determined that the evidence was exculpatory, because otherwise he would never have reached the balancing test and created a sanction. And in Key, this court said that the argument that evidence could have exonerated the defendant would be speculative, and that is exactly what the defendant argued here, that had he had these bills, they could have exonerated him. And I would submit that this court addressed precisely that question in Key and came to the conclusion that this is not exculpatory evidence.
Can I, so just to push you on your test, you would say your test, and you're prepared to rest on it, that if there is clear, controlling, unambiguously controlling Supreme Judicial Court or Appeals Court law on the point, that's the gateway through which you get, that's the chink through which you get a 211(3) petition.
That would be one of the gateways.
Okay. And you don't have to reach another one in this case because you are prepared to rest on the fact that Commonwealth against Key directly controls this case.
Is directly on point. And the effect of the judge's sanction in this case, which was just too extreme, would be to, in fact, create reasonable doubt in this case. Because the sanction as it has been issued, and I submit that because the judge had a different option before him, limiting it to Sergeant Fitzpatrick's testimony, but chose to go beyond that. He in fact meant to exclude all mention of buy money in this case.
And you know that because what? You said nobody asked him what he meant.
That is correct, but defendant's motion to dismiss posed an alternative to say either dismiss the complaint or issue a sanction saying Sergeant Fitzpatrick is prevented from testifying about the buy money, and he's the one who marked the bills and later compared the bills to the written down serial numbers. So
the undercover police officer who actually engaged in the sale could have testified.
According to under the proposed sanction proposed by the defendant, Officer Stoddard could have testified that he used the money and he purchased drugs in the car, and then he gave the money back to Sergeant Fitzpatrick. But the sanction as written by the lower court judge is just much broader and would preclude all that testimony. It would preclude even, I suppose, testimony that other money, $1,402, were found on the defendant.
No, it couldn't possibly.
Well, because
it's buy money. It used the word buy money.
Well, it is buy money. It would be another form of buy money. So the jury or the fact finder here would be confronted.
I have to say, you're not going to persuade me on that because the Commonwealth didn't ask to go back. I mean, you've got at least me saying it couldn't possibly mean that. So at least there's an ambiguity in what the judge is excluding. And the Commonwealth, if it's going to use this extraordinarily rare remedy, at least should make clear precisely what the judge intended. I mean, the other money was money he had on his possession that had nothing to do with coming from the undercover police agent, right?
Certainly. However, even if those $1,402 were the only testimony about money remaining in the case, the jury would be confronted with a drug transaction without money. And I submit it would still be the crime of distribution if someone gave drugs to another person without receiving money in return, but I submit that commonly a drug transaction is understood to mean that it involves money. And where there's no money mentioned, no buy money mentioned in the case at all, the jury could have a reasonable doubt that this transaction ever occurred. And there are no further questions. The urge this court to affirm the single justice's order vacating because he did not abuse his discretion.
Thank you, Ms. Saxe.